Good afternoon and welcome back to the Public Service Commission. We are continuing with the hearing in docket number 2022-238E. Let's take a roll call of commissioners. With us virtually, we have Commissioner Irvin, and present in the hearing room, we have Commissioner Justin Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Carol Lee Williams, Commissioner Caston, and Chair Belser. I believe the company is through with their case. Is that correct? Thank you. We will now hear from Carolina's Clean Energy Business Association, CECBA. Oh, Mr. Witt, before you begin, let me just say a little bit about our schedule. We need to recess today by 5 o'clock at the latest, and I'm not hurrying anybody because we have all week scheduled for this hearing. If we do not conclude today, we will resume the hearing at 9:30 in the morning, just so you're aware for planning purposes. Just wanted you to be aware. Thank you. Mr. Witt.
Thank you. Thank you, Vice Chair. Excuse me, I'm going to do what Matt did now. Chair Belser, thank you. CECBA calls its witnesses as a panel, Hamilton Davis and Steve Levitas.
Mr. Davis and Mr. Levitas.
Gentlemen, if you would raise your right hands, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
We'll start with Mr. Levitas. Mr. Levitas, will you state your name and business address?
My name is Steve Levitas. My business address is 130 Robert Street, Asheville, North Carolina, 28801.
By whom are you employed in what capacity?
I am the Senior Vice President for Regulatory and Government Affairs with Pinegate Renewables.
On whose behalf are you testifying today?
The Carolinas Clean Energy Business Association, or CECBA.
Did you prepare or cause to be prepared direct testimony consisting of 28 pages?
I did.
Do you have any changes or corrections to that testimony?
I do not.
If I ask you the questions on that testimony that identify it as being directed to you, would your answers be the same?
They would.
Okay. Hamilton Davis, please state your name and business address.
Hamilton Davis, 1519 King Street. Hamilton Davis, 1519 King Street, Extension, Charleston, South Carolina, 29405.
By whom are you employed in what capacity?
I'm employed by Southern Current LLC. My title is Vice President of Markets and Regulatory Affairs.
Who are you testifying on behalf of today?
On behalf of the Carolinas Clean Energy Business Association.
Did you also cooperate to prepare, cause to be prepared direct testimony consisting of 28 pages?
I did.
Do you have any changes or corrections to your testimony?
Not at this time.
If I ask you the questions that identified as being directed to you, would your answers be the same?
They would be.
Chair Belser, we would move that direct testimony into evidence as if given orally from the stand.
The testimony labeled direct panel testimony of Hamilton Davis and Steve Levitas on behalf of CECBA will be entered into the record as if given orally from the stand.
Okay, thank you. Mr. Levitas, did you prepare a testimony of your direct testimony? Excuse me, a summary of your direct testimony?
I did.
Would you please give that summary?
Yes, I would. Good afternoon, Madam Chair, members of the Commission. My name is Steve Levitas. As you heard, I'm Senior Vice President for Regulatory and Government Affairs with Pinegate Renewables. Pinegate is a utility-scale solar and storage developer based in Asheville, North Carolina, and we have developed and constructed numerous solar facilities here in South Carolina and have quite a lot of additional facilities under development. In my direct testimony, I describe my work in the solar industry over the past 13 years. Of particular relevance to this proceeding, I was extensively involved in the development and passage of legislation in North Carolina, which created a new program of competitive procurement of renewable energy resources in Duke Energy's service territory. I was then also heavily involved in the preparation of comments to the North Carolina Utilities Commission on rules implementing Duke's CPRE program. On October 23, 2018, and again on June 12, 2019, I made allowable ex parte presentations to this commission concerning competitive procurement of generation resources. In 2020, I co-chaired the subcommittee on competitive solicitation of the North Carolina Energy Regulatory Process, which produced a set of consensus policy recommendations relating to competitive procurement. In 2021, I provided direct and rebuttal testimony in this commission's generic proceeding on competitive procurement of renewable resources. That was docket 2019-365-E on behalf of the South Carolina Clean Business Alliance, which was the predecessor to CCBA. And I've also served as faculty on continuing legal education programs regarding competitive procurement. My portion of the direct panel testimony filed by Mr. Davis and me begins by discussing the benefits of a well-designed competitive program. The first and biggest benefit is what we see from competition across our economy. Competition drives prices down and improves the quality of service for consumers, as multiple sellers must strive to innovate and achieve efficiencies or accept lower returns in order to acquire and maintain market share. Additionally, competitive procurement by definition involves opening the market to independent suppliers rather than allowing investor-owned utilities to self-develop all generation assets. This diversity of suppliers results in access to broader and more diverse development expertise, many additional sources of capital, and a larger workforce for the development and construction of generation facilities. And to the extent that competitive procurement involves execution by the utility of power purchase agreements with third-party suppliers rather than utility ownership and rate basing of generation assets, those third parties bear the risk of cost overruns, as well as any performance shortfalls following commercial operation. In response to the specific questions the Commission asked parties to address in this proceeding, I offer the following responses and opinions on behalf of CCBA. First, CCBA strongly believes that utility competitive procurement should be driven by an IRP or other similar resource planning processes in most cases. The most important threshold questions in the procurement of generation resources by regulated utilities such as DSC are the volume of generation capacity needed and either the specific type of resources needed or the required performance characteristics of those resources. Those aren't the only questions, but I said they're the primary ones. These questions are best answered through a comprehensive, transparent, and inclusive planning process. Second, CCBA recognizes that there are benefits to so-called all-source competitive procurements in that they provide an opportunity for the utility, with the approval of the Commission, to develop an optimal resource portfolio after determining the actual capital cost of various generating resources, rather than having to rely on estimates or projections of those costs. However, CCBA understands the focus of this proceeding to be on the procurement of renewable energy as provided for by the South Carolina General Assembly through Act 62, which authorized this Commission to develop a competitive procurement program specifically for renewable energy resources. And we talk about some reasons why that would be beneficial. Third, CCBA believes that the least cost and least risk energy supply that best serves ratepayers in the public interest should include independent market participants in competitive solicitations. Not only have independent power producers, such as our companies and other CCBA members, consistently been able to deliver renewable energy at lower costs for customers, but independent power producers, rather than ratepayers, as I mentioned, also bear the risk of delay, cost overruns, and underperformance in a way that rate-based assets do not. Fourth, we agree that there should be reasonable and transparent eligibility standards that are developed through a stakeholder process and approved by this Commission. Fifth, assuming that utilities are allowed to participate as market participants in a CPRE process, to ensure a level playing field and avoid any appearance of impropriety, the utility should be required to maintain a strict firewall between its bid team and its evaluation team. Sixth, our understanding is that most competitive solicitations for electric generation resources by investor-owned utilities in recent years have involved some form of independent oversight. The key question is whether the solicitation is fully administered by an independent third party, which we have referred to as an independent administrator, or IA, or whether the utility should be allowed to administer the program under the oversight of an independent party, typically referred to as an independent evaluator, or IE. In our opinion, the answer to that question turns on how the program is designed, and specifically on whether and how the utility and or its affiliates are allowed to participate in the procurement. To the extent that the utility or its affiliates are allowed to compete directly with independent suppliers, the need for an IA is much greater. Regardless of the choice between an IA and IE, the utility and that party should work together with stakeholders on the design of the program, including scoring criteria, the weighting of those criteria, and the evaluation and selection process. While we would recommend that certain elements of program design be subject to Commission approval, it may not be necessary for all RFP documents, such as some of the ones you heard described this morning, to be approved by the Commission. Seventh, we believe that it's in the public interest for bidders to have as much information as possible about the transmission and distribution system and where new generation can most effectively be sited. And if utilities and their affiliates are allowed to participate in the competitive process, it's essential that all market participants have access to the same information about the transmission and distribution systems as the utility does. Eighth, we acknowledge that other states, including North Carolina, Virginia, Colorado, and Michigan, have provided for a specified mix of third-party owned and utility-owned generation. Where that occurs, the two types of resources are typically procured through separate requirements within the procurement process, not in competition with each other. Regardless, we believe that generation that will be utility-owned should itself be competitively procured, and third parties should have the ability to compete with the utility and its affiliates to supply these resources. And to be clear, we don't think it's appropriate for utility affiliates to compete in third-party procurements where the utility has its own set-aside of resources that it gets to own. In my direct testimony, I also identify competitive procurement programs that have been implemented by utilities in other southeastern states. In addition to North Carolina, which I've already discussed, those include Dominion Energy in Virginia, Georgia Power, Alabama Power, Santee Cooper, and TVA. Our direct testimony provides links to detailed information about these programs. And I gather, Mr. Witt, that you want me to, I don't have much to say about Sir rebuttal, but am I supposed to wait on that?
You should wait on that.
Okay, well, thank you very much. That is the summary of my direct testimony.
Mr. Davis, did you prepare a summary of your portion of the direct testimony?
I did.
Can you present that at this time?
Yes, I can. Good afternoon, Commissioners. Thank you for the opportunity to testify to you today. Just briefly by way of my background and my role at the company, I manage Southern Current's regulatory engagements before the Federal Energy Regulatory Commission and multiple state utility commissions, including the South Carolina Public Service Commission and the North Carolina Public Utilities Commission. My work also supports the company's policy initiatives before various state legislatures, as well as the company's commercial interest in wholesale and vertically integrated markets across the country, including contributions in the creation and participation in renewable resource procurements. Moving on to my direct testimony and initially focusing on Dominion's integrated resource plans, my direct testimony includes an overview of the recent Dominion IRPs from 2021 through 2023 and details the additions of solar and storage resources that have been identified in the company's preferred resource plans. For the 2021 IRP update, this commission found the company's IRP to be in the public interest, and this plan included 400 megawatts of solar and 100 megawatts of storage to be added to the Dominion system in 2023. I clarified that no further action was taken by this commission to require procurement of those resources, nor did the company initiate a procurement on their own. I note that Dominion is currently conducting an all-source procurement for the replacement of peaking capacity on its system, which is a separate system need than the solar and storage resources identified in its IRPs and is specific to planned retirements for certain peaking generators on Dominion's system. Also discussed the 2022 IRP update, which includes near-term solar and storage additions from 2028 to 2032, as well as solar additions for years 2033 through 2038. I provide details on the 2023 proposed IRP, wherein Dominion indicates, quote, Solar resources and battery storage emerged as a major contributor in each of the core build plans, with solar representing between 59% and 67% of the resources added on a nameplate basis over the planning horizon, and battery representing 13% and 22% of those resources. The 5 core build plans add between 4,275 megawatts and 7,500 megawatts of solar, and between 1,500 megawatts and 1,600 megawatts of battery, end quote. And then Dominion further states that its preferred build plan in the 2023 IRP, quote, adds a total of 5,225 megawatts of solar and 1,600 megawatts of battery over the planning horizon, and adds solar in every year from 2026 through 2049, end quote. And finally, I testify that both Dominion Witness Best and CCBA support using an approved IRP as a foundation for informing the need and timing of renewable energy and storage procurements. And Witness Best and CCBA also recognize that other planning processes may be appropriate for identifying utility system needs that could inform a competitive procurement. Second part of my direct testimony focuses on CPRE timing considerations and discusses the lengthy lead time required for the development, approval, and utilization of a CPRE program. I note that from the design and approval of Dominion's ongoing all-source RFP for new peaking capacity to the required in-service date for selected facilities, that timeline represents almost 6 years. And given that Dominion has identified significant additions of solar and storage resources beginning in 2026, CCBA recommends that this commission order a process for approving a CPRE program in 2023 so that Dominion will be able to immediately move forward with a procurement in 2024 as appropriate based on its approved 2023 IRP. It will take some time to design, develop, and get approval for a CPRE program on the front end, and once a CPRE program is approved, conducting an actual procurement and placing new facilities in service will necessarily take significant additional time. The interconnection study and evaluation phase of a procurement will take between 630 and 780 days, followed by 12 to 24 months for construction of a renewable facility. To the extent that any network upgrades are required to interconnect new resources, that could add another 2 years to this timeline. And given the assumptions about solar and storage additions in the 2023 proposed IRP, it would be imprudent to further delay the design and approval process for creation of a CPRE program. And this concludes the summary of my direct testimony.
Thank you, Mr. Davis. Mr. Levitas, did you prepare cause be prepared servable testimony consisting of 11 pages?
I participated in the preparation of that rebuttal testimony with Mr. Davis at the request that our answers be bifurcated. Most of those answers were provided by him, and my personal responses were limited to affirming his responses.
Do you have any changes or corrections where you identified as being the witness providing an answer?
I do not.
If the same questions were directed to you today, would your answers be the same?
It would.
Mr. Davis, did you prepare cause be prepared servable testimony consisting of 11 pages?
I did.
Do you have any changes or corrections where you identified as being the witness providing an answer?
I do not.
If I ask you those same questions today, would your answers be the same?
They would be.
Chair Belser, we'd like to move the 11 pages of CCBA servable testimony into evidence as if given orally from the stand.
The rebuttal testimony of witness Davis and Levitas filed on behalf of CCBA will be entered into the record as if given from the stand.
Thank you. Mr. Levitas, you have a short summary of your participation.
My summary just consists of concurring with Mr. Davis's answers.
Okay. Mr. Davis, you have a summary of your servable testimony?
I do.
Would you present it at this time?
I will. So in my rebuttal testimony, I discussed the fact that Witness Best does not substantively address or respond to my direct testimony on the significant timing considerations related to the creation and approval of a CPRE program in combination with the timelines associated with Dominion's interconnection study process and the construction of renewable energy facilities. I also provide a revised timeline that demonstrates under a best case scenario that assumes a CPRE program could be proposed and approved by this commission within 3 months, that it would still require approximately 3 years and 4 months to place a new renewable energy facility in service through a competitive procurement process. This means that it is unlikely that a procurement conducted in 2024 will result in renewables being added to the Dominion system before 2027, a year later than solar additions in the 2023 proposed IRP indicate. Nonetheless, CCEBA still recommends waiting until a final IRP order is issued before any competitive procurement occurs. Also discuss the fact that witness best rebuttal testimony focuses primarily on Dominion's capacity needs as identified in its proposed 2023 IRP, and I point out that South Carolina Code Section 583740, the IRP statute, requires consideration of a utility's overall system needs, not just its capacity needs, including the development of a resource portfolio that meets the system's energy needs in the most reasonable and prudent manner. This determination includes a balancing of factors specifically identified in the code, consisting of capacity, consumer affordability, compliance with environmental regulations, power supply reliability, commodity price risks, diversity of supply risk, diversity of generation supply, and other foreseeable conditions that the Commission determines to be in the public interest. The repeated distinction that witness best makes in her testimony regarding Dominion's capacity needs while de-emphasizing any energy needs is not supported by a plain reading of the IRP statute, which requires an analysis of both energy and capacity, and also requires that this Commission determine whether an IRP is the most reasonable and prudent means of meeting a utility's capacity and energy needs. Finally, I testify about why a technology-neutral, all-source procurement process may be needlessly complicated, time-consuming, and expensive as compared to single-source procurement where, as in this current instance, a specific technology resource has been identified in an IRP as being the most reasonable and prudent for satisfying the statutory requirements of the IRP. Dominion's 23 proposed IRP indicates that whatever new resources may be added to its fleet, there's a need for solar additions as early as 2026. And not only does solar represent a least cost form of generation, it also offers portfolio diversification, fuel cost stability, risk hedging, which are all statutory considerations made during the IRP process. Given the unpredictable and variable cost of fuel-based generation like coal and natural gas, an IRP that includes a fixed cost energy resource like solar would not benefit from a subsequent all-source procurement process, which could substantially increase complexity, expense, and time required for that procurement. However, CCEBA does support targeted all-source procurements, such as the ARC procurement. Typically, those all-source procurements are better suited to general capacity replacement needs on a utility system. In conclusion, I testify that because Dominion has significant near-term solar and storage additions identified in its approved and proposed IRPs, competitively procuring those resources in a timely manner will result in a cost-effective and predictable mechanism for meeting Dominion's system needs consistent with the public interest. And due to the long lead times required for the creation and approval of a CPRE program combined with the lengthy interconnection study and construction phases of CPRE, it's imperative that this Commission direct Dominion to immediately undertake the requisite activities necessary to establish a CPRE program. And for the sake of clarity, we're not recommending volume or timing issues be decided in this proceeding. We're just recommending that a directive be given that a CPRE program be worked on with stakeholders and filed with this Commission for approval and for future use. And this concludes my rebuttal testimony.
Thank you, Mr. Davis. Chair Belser, CCEBA's panel witnesses are available for questions.
Thank you, Mr. Witt.
Thank you.
CMC Steel, South Carolina. Questions? Hearing none. SACE CCL.
Good afternoon, Mr. Davis and Mr. Levitis. Just have a few questions. Now, how many competitive procurements have each of you participated in as bidders?
Well, my responsibility with my company is not participating or running our participation in the RFPs. So I don't have ready access to the number of competitive solicitations on behalf of the company. but it's many, a lot.
Yeah, recently, the last couple of years, we've participated in procurements held by Duke, Santee Cooper, Dominion, TVA, Alabama Power, Consumers Energy in Michigan, to name a few.
Okay. And you both participated in the Urquhart RFP stakeholder process, correct?
I did, yeah.
I did not personally.
You did. Okay. Well, then maybe I'll direct this at you, Mr. Davis. Did you hear Ms. Best testify earlier that Dominion believes they have a CPRE framework in place based on that Urquhart RFP stakeholder process, and they believe they can use that framework to effectively implement a CPRE when a need is identified?
I did hear that testimony.
And do you agree with that?
I agree that going through the all-source procurement design process added a foundation for us to work from, but the details of solar-specific CPRE type program or even future all-source procurements that target different resources like coal retirement and replacement will require additional stakeholder engagement, and our recommendation is commission review of final documents and program design.
Okay,
And I'm sorry, I do know enough about that procurement, I think, to respond to your question,
Okay.
if I may. And I would say that I would echo what Mr. Davis said, is that there are certainly elements of that procurement that are useful information and experience going forward, but there are many elements of energy procurement program design that have either not been addressed at all in that process, or were addressed in a limited way because that was a one-time procurement for a particular purpose that was done by virtue of a settlement that was intentionally, on our part, seeking to minimize conflict, not bring matters to the commission and get on with that procurement because of the time sensitivity. But just as an example of some of the other types of issues that have not been resolved, I spoke in my testimony about the critically important issue of ownership split, a decision made of, do you have any kind of defined allocation of what resources are going to be owned and rate-based by the utility versus covered by third-party PPAs? That issue has not been resolved in any way definitively. It's an issue that should be resolved by this commission, not by private parties. And that has not been addressed at all. That issue alone has taken months and months to address and resolve in other states where it has been addressed. And as we say in our testimony, it has been addressed and needed to be addressed in other contexts. Another huge issue that has not been resolved is the treatment of and the allocation of cost responsibility for upgrades that are identified by projects in the competitive procurement process. That is another issue. Months and months of engagement and commission involvement have been required in other states to address that issue. PPA terms and conditions, particularly if you're going to have solar plus hybrid resources. Right now in North Carolina, we have been at it for months, and I mean months, trying to figure out this complex issue of how the PPA should be structured. And when Dominion had their own solar and storage tariff that was put in place some time ago, I was involved with the negotiations over that tariff. That took a long time to put in place. So those are just a kind of few of the things that have not even really begun to be resolved, and it would require extensive time, in my opinion.
And so you sort of anticipated my next question, but
Excuse me, Chair Belzer. I wanted to let the witnesses fully complete their answers, and this is just for the record. For purposes of the record, preserving the record, I think we need to be clear when a question is asked to a witness to let that witness answer. A question can then be asked to the other witness, but we need a question to the witness and not witnesses chiming in to help each other answer a question, just for purposes of the record. I want to let you
Noted
both
and
fully
understood, so,
yeah, certainly.
Chair Belser, can I be heard?
Mr. Witt.
I've been in a few hearings in the last couple of decades, and you repeatedly see when the utility or any other party utilizes a panel that one of the other panel members, subject to the chairman's supervision of that, can offer to answer the question, and it's not usually objected to. It's just more information for the commission. So we would think it's entirely proper for both to weigh in. It was the reason that we selected the panel format. So we would just offer that we think it's fine that he offered to do that. There was no objection to the question.
I think going forward, she can ask it of one and then ask it of the other. We just need to be a little more structured, I think.
All right, thank you.
Thank you.
Well, this next question is directed at both of you. As you know, you've recommended in this docket that Dominion begin to work with stakeholders to develop a CPRE program. Am I correct in understanding, Mr. Levitas, that some of those items that you just listed would be what you would begin to work on were you to start that process now? I'm curious, you know, were Dominion to start to work with stakeholders now, what exactly would that look like at this time leading up to the period before the 2023 IRP proceeding is complete?
Yes, I think that was a pretty good summary of some of the major issues that need to be addressed. There is the issue of independent administrator versus independent evaluator might need additional attention. The potential participation of utility affiliates as well as the utility itself, the cost recovery mechanism for utility-owned assets. That may presumptively be rate basing, but there are other options that have been implemented in other states. And then, of course, all of the issues associated with scoring criteria, pricing, the structure of pricing. Yes, there's information from the Urquhart proceeding that may be useful, but it's certainly not definitive for all purposes.
Okay, so you're saying let's reach consensus on this list of issues so we can just go forward with the procurement when we have an approved IRP.
Correct.
And now, again, for both of you, I believe you both addressed this in your summaries. Why are you recommending that Dominion develop a renewable specific procurement at this time? Why do you think that makes more sense for Dominion for its near-term needs?
Based on the IRP, Dominion has identified adding solar every year starting in 2026 through 2049. And especially in those early years, these are energy resources. And so this concept of an all-source procurement versus competitive procurement of renewable energy, the IRP is essentially acting like an all-source procurement. It is looking at gas that already exists on the system and is projecting those costs into the future. What will fuel costs be over a 20, 25-year horizon? And then the model is selecting solar based on certain cost assumptions. And the value of the competitive procurement is you go out and then market test to see if those assumptions in the IRP are validated. But having an all-source procurement for an energy resource where there's not actually competition in the marketplace is, it defeats the purpose. And so, really the way the IRP is designed, the way the analysis has been done, what you're doing is just going out to determine whether this fixed energy resource is available at the prices assumed in the IRP that have been validated to be in the best interest of customers. And those are the steps that I think we want to take today, is getting that program in place. So to the extent that this commission approves the 23 IRP and it looks something like it does in its proposed form, there's an opportunity to immediately go do that. And I don't want to go beyond your question, but the timing considerations in terms of how long it actually takes to do the procurement and construct these facilities, that's really the urgency and the concern is let's have the program in place so it can be used in an effective way to meet an approved IRP expectations.
And if I might just elaborate on that, and I think it's responsive to your question, this notion of a CPRE versus an all-source procurement is something of a false dichotomy or a little bit misleading, because it sounds like, oh, should we go consider everything and compare those prices, or should we just consider one thing such as solar? Well, what's inaccurate about that is that the sole source or the sole technology CPRE methodology is the result of an IRP. As we've all said, there's consensus in this proceeding that it should be informed by the results of an IRP. An IRP is an all-source process. An IRP looks at all the resources, and the only difference between an IRP followed by a single technology procurement and an all-source procurement is that in the IRP, you're relying on expert testimony and an administrative determination about certain inputs to the process, namely natural gas projections and the capacity factor for solar. Those are the two big ones. Everything else in an all-source procurement has to be informed by the results of an IRP, projections about gas pricing. So it's the only way that you get to the point of doing a CPRE sole source procurement for renewables is if you have been through the IRP process and you have concluded in an IRP that there's a reason for a particular resource to be selected, and what happens in a competitive all-source procurement wouldn't make any difference. In other words, if the range of potential solar prices is not going to affect the amount of solar that you need as part of that plan, then there's no point in competing it against something else. Similarly, if you needed a gas resource for dispatchability reasons, and that's the only resource that can meet that need, you're going to have a gas procurement. And so I just think there's a little bit of a, as I said, false dichotomy to think, oh, well, what we're talking here is, do we just procure one type of resource or do we look at a lot of resources? Because that's exactly what you do in the IRP is you look at all the resource types.
Thank you. And I think you were kind of getting to this, Mr. Levitas, but Mr. Davis, you said in your answer something about, it makes the most sense to procure when you're looking at procuring an energy-only resource where there's no competition in the marketplace. And am I quoting you right? I just was wondering if you could expand on what you mean there in terms of, how solar would satisfy that be the only resource that would be satisfying that need right now.
Well, I mean, so if you look at like 26 through 2030 in the Dominion IRP, they don't have an energy need in the sense that they're short of energy. What they're doing is they're evaluating whether there are more cost-effective ways of meeting the load, the energy needs on the system. They already have the gas capacity on the system, and there's a forecast of what those costs are going to be, and that's all being done in the IRP. So if you had an all-source procurement, it wouldn't be the case that new gas would be coming in. The gas is already on the system, and the cost has already been assumed, but it's necessarily done in an administrative fashion because we don't know what those costs are going to be over a long time horizon. And so the only other resource in the market that's going to compete to supply that energy, in competition with gas that already exists on the system, is solar. If we had a wind resource, if we had, an expectation that biomass would bid in or small modular nuclear reactors would bid in, then you may want to open that up to find out whether there's an alternative fixed source that can compete with that gas that's on the system. But that's just not the situation we're in with the market. It's really gas or solar today on an energy front, and the IRP is what is indicating that it's worth going out to procure solar if you can get it at a certain price point.
Thank you. And now just one final question. In both of your experiences, how have the administrative costs of developing and hosting a CPRE been handled? Do bidders pay any of those costs? Have those costs been prohibitive? Just wondering if you could talk a bit about that.
In my experience, there typically is a bidder fee that is designed to cover those costs. And there's been a lot of participation in RFPs, so my guess is they're high, but I don't think they're prohibitive.
Yeah, just quickly to elaborate on that, bidders' fees are standard, especially to cover the cost of like an independent administrator or evaluator in the actual procurement process. I think Witness Best talked about, the members of her team that participate in constructing that and evaluating it. That I think those aren't necessarily included. That what the utility's doing is its job in evaluating resource options, and but to the extent they're outside costs like a consultant, then bidders' fees are standard offsetting those or paying for those.
Great. Thank you. I'll stop there. Thanks for your time.
Thank you.
Thank you, Ms. Clancy. Office of Regulatory Staff, I'm sorry. Yes, Office of Regulatory Staff?
No questions, Madam Chair. Thank you.
Thank you. Dominion.
Thank you, Chair Belzer. Good afternoon, Mr. Davis, Mr. Levitas. I know we know one another, but just for purposes of the record, my name's Ashley Cooper. Appreciate your participation. I have just a couple of questions for you this afternoon. And Mr. Davis, I want to ask you just a couple questions, and just for your ease of reference, I'm looking at page 21 of your direct.
Okay.
So, I mean, you can answer it probably without looking there, but just, it's really straightforward. I just thought it'd be easier for you to see it. And I'm looking at, you say, starting on page 16, you're describing this all-source procurement process, I believe. And you say the shareholder process resulted in the following materials which were necessary for moving forward with an actual procurement. And you list the RFP document describes the overall procurement process and resource needs of the company, notice of intent to bid, non-disclosure agreement, pre-qualification application, preferred technical specification by technology, key commercial terms for bid and ownership structure, standard RFP response form, RFP evaluation criteria. That's your pre-file testimony, and that's your testimony today, correct?
That's correct.
And Mr. Levitas, I believe that in separating out your testimony, is it clear, do you agree with Mr. Davis's characterization?
With respect to the need for those documents?
I believe Mr. Davis is saying that there was agreement reached with input on that list of information.
I don't have any reason to disagree with that.
Okay, thank you. And then, Mr. Davis, if you'll just stay on that same page, you say that there are additional materials, and you mention a pro forma, PPA, bid security, interconnection. Is that correct?
That's correct.
Okay. And it's true that your company, Southern Current, has executed PPAs with Dominion Energy South Carolina today.
Yeah, we have under SQFs under PERPA.
Thank you. And those are for solar procurements.
It's for solar.
For solar assets.
Yeah.
How about that?
Yeah.
Thanks. To the extent it was tricky, it was just not a good question. Mr. Levitas, and you recall that 2 years ago, Dominion Energy had a avoided cost docket, correct?
I do.
And you participated in that docket, correct?
I did.
And your testimony, maybe not focused, but a good bit of your testimony was dedicated towards the Commission's review of Dominion Energy's form power procurement contract. Is that correct?
That's correct.
And I believe, did you weigh in and make recommendations to this Commission on security and the security terms, commercial terms, that Dominion should adopt in its form PPA?
I did.
And the Commission adopted a lot of your recommendations.
As I recall, they did, yes.
Okay, so it currently has a form PPA for use with solar with your recommendations on security.
Well, with this exception, that was, as you know, in the context of a PERPA avoided cost proceeding. So those contracts were specifically for use with PERPA facilities and with solar only facilities. So there are different terms that can be negotiated, and one might say need to be negotiated in the context of a competitive procurement outside of PERPA, where some of the rules for PERPA don't apply. And then I mentioned earlier the whole structure of a solar plus storage contract, which is a horse of a different color, a very complex issue. And as I mentioned, there is a stakeholder process underway in North Carolina that is very, very complex and time consuming to try to reach consensus about those issues.
Thank you very much, Mr. Levitas. And Mr. Davis, Southern Current was able to negotiate with the company and execute a PPA for the sale of solar output to the company without the presence of a CPRE, correct?
Yeah, again, we have signed by right PERPA contracts with Dominion.
And Mr. Levitas, the same question to you, but I'll repeat it for the record just for clarity. I'm sorry, I apologize, but we usually get stuck writing the proposed orders. So I'm in addition to staying on Ms. Wheat's good side, I like to be able to write these orders. Mr. Levitas, is it true that Pine Gate Renewables has also been able to execute PPAs with Dominion Energy South Carolina outside of a CPRE to date?
Yes.
Okay, thank you. And Mr. Davis, and I'm not trying to put words in your mouth. Let me point it to your. I think you just stated it, but I'll turn to your testimony. It refers to the statement you made about to be clear. It's in your rebuttal, and it's to be clear. We're not advocating for moving okay, this is on page 6 of your rebuttal, and it's lines 7 through 10. And you say, to be clear, SECIBA is not recommending moving forward with a new competitive solar procurement until DESC's 2023 RFP has been approved, to the extent that an improved RFP identifies additional solar as well during the year. So I believe you just testified. Sorry, I want to make sure do you see where I am, Mr. Davis?
Tell me what line it is again, I'm sorry. Yeah, I got it. Line 7.
Line 7, yeah. So just to be clear, and you stated this earlier, but do I have this correct, that you're saying we're not advocating for moving forward with actually the issuance of an RFP and beginning construction until the 2023 IRP has been concluded?
Yeah, and only to the extent that the 2023 IRP supports that, moving forward with an actual procurement.
Sorry, please finish.
No, I mean, I just want to insert that, this whole line of questioning, I think, it points to the fact that there's, I think with the exception of Mr. Levitas has pointed out, there are some complicated things that need attention that we've just not worked on through a shareholder or stakeholder process. But the vast majority of the pieces are kind of in place. And it isn't a huge step to get from where we are to a filed program for approval. And, I think the timeline I put in my testimony was like 3 months, maybe best case. There's not a huge disagreement here. It's peculiar to me that the company isn't willing to take what I think is relatively straightforward steps to have this in place so that a program can be utilized to the extent this commission thinks it should be, and to the extent that the IRP looks similar to how it does today.
Well, I appreciate that answer because we've now skipped ahead of 2, 3, and 4 on my next question.
Okay.
So just but while you still have your mic on and your glasses off,
I would take that.
I'll ask you this one last question. So accepting what you just said and building off of what you just said, would you agree with me, though, that the company's next steps at some point, whether it takes next steps today, tomorrow, it's even if we take these steps tomorrow, Mr. Davis, once we have that IRP and we know what that 2023 adopt IRP states, whatever steps we take today, there's still going to have to be further steps that are taken to tailor a CPRE to the IRP that's adopted by this commission. Isn't that correct?
Well, I think the steps that would need to be taken are timing and volume generally, right? And that the other messier kind of nuanced details that you need just to stand the program up. That is where we have time to do that in 2023, so that in 2024 we're just doing a procurement and none of that activity is required. Because even though maybe 3 months is a best case scenario, I could foresee significant disagreements between the company and stakeholders on things like utility ownership, or should we be using an independent administrator or IE, depending on how the company's participating, or is there storage a part of this? So, there is the potential for it to take 6 months or 9 months. And what I don't want to see us do is get into Q1 2024, early Q2, and then start that stakeholder process and miss another opportunity to put solar on the grid in a timely fashion. Because then we're looking at 2028, 2029, and we just keep kicking that can down the road. So let's do what we know we need to do today is the point.
And I'll let you fully finish, but
Thank
but
you.
if you will, please listen to me. I'm asking a slightly different question. I'm asking this question. You mentioned just in your answer to me, you said, well, maybe we need solar plus storage, and maybe there's some details for solar plus storage. My point is that once we have the 2023 IRP and we have a final IRP that's been adopted by this commission, there are going to have to be items that are worked through, like solar plus storage, additional tailoring of a PPA. That will have to be done once there's an order from this commission adopting the 2023 IRP. That's all I'm asking.
Yeah, I mean, again, it's a timing issue. It's a question of whether or not this commission thinks it's wise to use the time we have in 2023 to get ahead of this work and potentially be ready to go out and run a procurement in 2024. And that is what we're advocating for, because we are already looking at a timeline where I think 2026 is unlikely, unreasonable based on expectations around interconnection and construction times. So,
Thank you.
yeah.
Mr. Levitas, I saw you nod your head. Would you agree with me that once the 2023 IRP is adopted by this commission, there may be additional items that have to be tailored in this CPRE to account for the final IRP that's adopted by the commission?
I think that's probably correct, but I wouldn't underestimate or discount the number of things that need to be done and can be done sooner than that. Yes, probably some tailoring, fine tuning, but in terms of where we are now and all that needs to get done, there's a lot of work to do. And I would just say that's true not only with respect to a CPRE program, but with respect to an all-source procurement program. I don't think there's been enough attention paid in this proceeding this morning to how complex it is to design a full-scale all-source procurement program. We had a one-time, one-off, replace one facility all-source procurement in the case of Urquhart. But if you look at states and utilities that have done full-blown IRP-driven all-source procurement, the amount of lead time to develop those programs is a very long time. And they're complicated.
Thank you, Mr. I'm sorry. You
Yeah, no, they're complicated.
Yeah, thank you. So I want to follow up on that. That's a good point. Mr. Davis, in your rebuttal testimony, if you look at page 9, please.
I'm there.
All right, so could you please read into the record? Well, I'll do it for you. You've got glasses on.
I can't see with my glasses on if you want me to read it.
I'll
let you do it, though. I want to hear my words coming out of your mouth,
I used to
Mr.
be able
Cooper.
to see. Up until 6 months ago, I could see too, Mr. Davis. I'm going to look at line 10 of page 9, Mr. Davis. It is important to note that the design of a more comprehensive all-source procurement regime, which should focus on all energy and capacity ancillary service needs of utility, is a complicated process that requires extensive stakeholder engagement. Did I read that correctly?
You did.
So we have to date as a shell, a byproduct of an all-source procurement, correct?
Yeah, I would say, and I try to make this distinction. You'll see I use the word targeted all-source procurement and single source procurement and comprehensive all-source procurement. So I'm happy to elaborate on that, but there's a distinction there. And I would say that Urquhart was a targeted all-source procurement.
Okay. Thank you very much, gentlemen. I appreciate your participation today. I have nothing further.
Thank you, Mr. Cooper.
Thank you, Mr. Cooper. Commissioners, questions for this panel? Commissioner Caston.
Thank you, Madam Chair. Mr. Davis, Mr. Levitas,
Commissioner.
I may need to borrow your glasses.
I can bring him up. Just let me know. I'll need him back if you ask me to refer to testimony, though.
on page 9 of your direct, and you don't have to look at it, I'll just read it. You stated, well, I'll let you both decide if both of you stated this. SECEBA strongly believes competitive procurement should be driven by an IRP or other similar resource planning processes. And, I've heard that a few times. And SECEBA strongly believes that. And I guess I was just thinking, looking at you two gentlemen, Mr. Davis, Mr. Levitas, do you agree? Do you believe that statement?
Yes,
Sir.
I felt like you would, but I thought I would at least ask. And this is not a loaded question. This is really for my benefit because I only know your background based on what you're saying. I don't Google you.
it's boring.
Either now in your roles or in previous roles, have you been involved, I guess personally, with developing or implementing master plans, or I'm not going to say IRPs, but anything like that? I call them master plans. IRP meant nothing to me until I got here.
I mean, I've been involved directly in a number of the IRP proceedings, and is that what you're referencing, or
Well, not really, but that's good
outside
enough.
of the energy world? Yeah.
Well, if you're desperate, I have.
Okay.
I spent a lot of my life as an environmental lawyer, and part of what I did in that capacity was work on comprehensive river basin plans, including for the Yadkin PD River. So I tend to be a kind of comprehensive system thinker. I like those approaches.
I have been involved in comprehensive land use planning in my former incarnation as well. So,
Well, I wasn't going to put Mr. Levitas over you that he was better or smarter. Don't worry about that. So if you were involved with the PD, you found out they don't have any dams on that river downstream in South Carolina, do they? And the reason I ask that, because as I hear all these conversations, trying to piece it together and try to understand what I think I'm hearing, is, I kind of go, I'm just like anybody else. I can only go on my past, what I learned, what I experienced. And dealing with the master plans, what we call master plans in my previous work, we'd have a 20-year master plan and we'd break it into 5-year bites. And the first 5 years, you felt a lot more confident about those than you did the last 5 years. And then every year, we'd kind of reevaluate, says anything changed? Everything the same, which in essence is, I think, what the IRP is, because annually they have an update. And the purpose of that update is,
reevaluate.
yeah, anything changed? So when I think about that, and going back to, I've got a cerebral summary, a lot of different things here. But I think, Mr. Davis, this was you, where you testify about why a technology-neutral all-source procurement process may be needlessly complicated, time-consuming, and expensive as compared to single-source procurement, where it's already been identified in the IRP. And then I went to the cerebral to see why, and basically what you have in that bullet's about what you said there. But I think in the questioning back and forth, what I think I've heard is that, look, all source and technology neutrals can be time consuming, not necessary if it's already been identified in the IRP. Is that what?
I think that, yeah, I mean, that's part of it, is that the IRP is kind of, the modeling in the IRP at least is acting as something like a technology neutral analysis of all the different ways that Dominion can meet its energy needs on its system. So it's testing both its capacity and energy needs against essentially all technologies that they view as being viable today in the marketplace. And when you have, I mean, but this is like this is the last piece of this that I think is super important to appreciate when you're talking about a fixed energy resource versus an administratively presumed, gas forecast, fuel forecast, is you're not going to have natural gas come into an all source procurement and bid in as a fixed energy resource. So, like, I don't think Dominion would suggest that's going to happen. So you're always going to have to make an assumption on the natural gas side as to what those costs are going to be over time. And that is what's being done in the IRP, is looking out over time and then using that forecast. And then you are also making an assumption about solar. Is it cost effective as compared to that natural gas forecast? If the IRP says yes, then you want to go to the market and see if you can actually procure it at that cost. But having an all source procurement where gas is competing against solar at that stage of it doesn't make sense, because gas isn't going to bid in as a fixed resource. You're just going to have to do the same thing you did in the IRP already, which is use a curve, a forecast, and then compare it against the market cost. But you already know what that curve is because it was identified in the IRP, and you know what cost it's in the public interest to procure solar at. You've decided that in the IRP, and then if you can go get it from the market, then you get it. I mean, because I'm not running away from this idea of all source procurement. I think all source procurement's a good idea when you have uncertainty around which resource or which combination of resources can most cost effectively meet a need. But when you have a fixed energy, in this fixed energy situation, or in an energy situation, it's different than like the peaking capacity, where it could have been a 50 megawatt gas plant, and it could have been 150 megawatts of storage and then some solar, or it could have been 200 megawatts of gas and no storage, no solar. Like, you're letting all those things compete for that capacity resource, but that's just not, that isn't the case with the solar that's being identified in their IRP that's based on a pure energy need.
Might I add a little on that?
Certainly,
Do
certainly.
you have any questions for me? I want to make sure I'm clear, though, and not just rambling. I feel like I'm rambling a little bit.
I may well. Let me hear
Okay.
Mr. Levitas, and I'm hoping he can probably answer that in just a few words less than you. But
Well, what I was just going to, I wanted to first of all reiterate the point that I made earlier, which is the integrated resource planning process, the way South Carolina requires it and the way you have conducted it historically, is an all-source process. I want to just emphasize that. That is a means of looking at all resources and developing, as required by law, the most prudent and reasonable portfolio. Do I have the words right? Most prudent and reasonable portfolio based on all of the evidence that you hear in that proceeding. So that is an all-source process. And let's say you have, a gigawatt of gas and a gigawatt of solar, and maybe there's some wind in there someday, and that's what you conclude in your proceeding. So then the question is it in the public interest at that point to just go out into the market and procure the things that you identified through that, as you know, long, deliberative, careful process, or is there something to be gained by going into the market and retesting it and competing all those things against each other, and to see if you get a different result than what you concluded in your planning process? And there could be some circumstances where that would be helpful. There are others where it's not going to be helpful or necessary. For example, if you had made a decision requiring considering all the factors that you're required to consider in that planning process, and you said, whatever else we do, we need fuel diversity. That is a requirement to protect the ratepayers of South Carolina, and we know we need this much fuel diversity, then there's nothing to talk about in an all-source procurement. And I think I said this a minute ago. If you decided by the same token, you have got to have this much dispatchable, non-intermittent resource as part of that plan to ensure that you've got reliability of the system, then that's what you've got to have. And so there could be some places where there are gray areas where you would say, well, it depends what we learn in the market as to how we would make these decisions and what that resource portfolio would look like. But I would suggest to you that those are going to be fairly limited, particularly when you don't have a viable wind resource in the state at this moment. Where all-source procurement has been most effective is in Colorado, where you had multiple resource types. So you could have wind and solar and storage and gas all bidding against each other and all being evaluated against the premise of continuing to operate the coal plants. Here it's more limited.
Believe it or not, Mr. Davis and Livis, I really think I followed pretty much what you said, and I understand that. I think you points made, and I don't want you for a moment to think, this is some kind of trap question or whatever. I don't do that. I have no interest in that. I'm really trying to understand things. And as I listen to Mr. Cooper's questions, and thinking about what Ms. Best said earlier, and just thinking about, hey, how I grew up and what we did, I'm trying to piece all this together and say, okay, what makes sense? And I believe everybody has excellent points. And as I think about what, in the IRP, the things to be considered, it doesn't say consider this one more than you consider this one. We consider them all.
Right.
Which I think it was in somebody's testimony, as a matter of fact. I can't remember.
Yeah, we spell it out in rebuttal in particular.
But I guess having said all that and heard your responses, if what Ms. Best said earlier is true, I mean, she believes it to be true. Apparently Dominion believes it to be true. Clearly, you guys don't quite embrace that view or share that view. But if it's going to be, if an IRP is updated every year, and it seems like everyone said that this process can be complex and costly, I'm trying to, I really am. I'm trying to get my head around, why does this make sense? Why does this make more sense than just doing a all source or technology neutral, and every year look and see, has anything changed? Does this make more sense? Or batteries now more practical? Does that make sense? What I just said?
Yeah, I mean, I think it. I mean, it again, I think depends on what it is you're testing, what you're using the procurement for. And so you're not, like, there's an annual need for solar. I mean, they show solar coming on every year from 26 through 2049. So you could run a procurement every single year for just, 300 megawatts and then run the same thing the next year. Or you could try and procure multiple years through a single procurement. Georgia Power does this. They don't just look at a single year, they look at multiple years. When they run theirs, as do other utilities. So I mean, they're different. There's certainly different ways to iterate, and there are going to be times when you want to use, in our opinion, a single source procurement because it just doesn't add anything to do all source, and then there are times when you want to do all source. But you're not going to do an all source procurement every year because generally, in our minds, you're doing that for a capacity need. So Dominion has identified some coal retirement dates in 2028 and 2030 for Williams and Wateree. And those would be good opportunities in our mind to use all source procurement to make sure the combination of resources that's replacing that capacity meets the standard this commission set in the IRP in terms of public interest. But again, I mean, what we've tried to do is delineate this situation where on the energy side, it's really just a question of, do you want to rely on the gas forecast and assumptions that for existing gas capacity in the system, or do we want to hedge that based on the economics in the modeling in the IRP and find out if the market can deliver those prices? And if it can deliver those prices, the assumption is it's in the public interest because it meets those cost criteria, risk criteria, balancing factors in the IRP that you use that resource planning process to really refine. And we really only do that once every 3 years in a substantive way. The other updates are much less rigorous in terms of changes and whatnot.
True, and I follow what you just said. Pretty sure I did. And if what I heard earlier, with the, I guess, cost or availability or whatever with solar or solar panels, I guess that wasn't anticipated when that IRP was done?
Yeah, I'd like to speak to that just for a moment. I mean, I think, so, I mean, what you've seen with solar, you've seen with with a lot of commodities, a lot of resources. Post-COVID, we had inflation, we have supply chain issues, workforce-related issues, and so you didn't see some of the cost curves perform in the way that they were expected to in 2019. But the point of it, Witness Best mentioned that they use NREL ATB price forecast in their IRP. So that's a forecast that's put out there by U.S. Department of Energy, and it's a good proxy. But what you want to do is run sensitivities on that price, because you don't know exactly what the market's going to deliver. It may be a little bit higher, a little bit lower. What we don't know is what the elasticity of that price is in terms of still delivering good value to customers. So it could be NREL, yeah, it's too low, but if you add $2 per megawatt hour to that cost and then you run the model, it still selects that much solar. It still says, well, this is still a good deal for customers. It could be $5 or $10 above that. Or you could use, Dominion's avoided cost as a proxy over 25-year period, and use that as a ceiling. We're only going to procure up to avoided cost. And that's because we know at that point, it starts becoming a cost to customers instead of an avoided cost or a savings to customers. And that's how the Duke procurement's been run in North Carolina for the last 3 years. So, there are ways to make sure, to test your modeling and your assumptions and make sure the market's actually delivering something that's valuable. And so the NRL ATB cost not matching up to the market isn't, in and of itself, it doesn't tell us much in and of itself.
Would that be similar to, say, like the gas market where, okay, the prices just skyrocketed up and, the sky's falling, and then, they've dropped recently? In other words, is everything, let me ask this. I was going to ask, it seems like solar could be volatile some, depending on how and when you can get the devices. I'm not saying it is like gas, but it seems like there's nothing fixed in stone.
Yeah, I mean, it's not volatile over the contract term.
Right.
There can be volatility year to year depending on macroeconomic factors that come into play. But, like as for anything, prices can change year over year. And that's why you want to test the market and not you wouldn't want to just go procure regardless of price. You would want to test the market to make sure the price that you modeled is available. And then if it is, you contract under that cost.
And can I ask this, and it actually has nothing to do with any of your testimony, I don't think. I've just been curious about this for some time. As far as the manufacturing of panels, the parts, whether it uses rare earth metals, whatever, how much of that is domestic? How much is foreign? How secure is it, I guess, is what I'm
Well,
curious.
that's a question that I spend a lot of time on these days. And there's a massive effort underway to onshore solar manufacturing. There's significant incentives in the Inflation Reduction Act for that. But unfortunately, the reality today is that the vast majority, all the way up the supply chain for solar, is made overseas, much of it in China. And we are very, very strongly committed to getting independence with respect to the supply chain, and particularly independence from China. So I give you a long answer of what's going on. There's been huge announcements of module production in the U.S., multiple gigawatts. The cells are going to take longer, the wafers that the cells are made from. But there is a huge amount of attention being devoted to that with the goal of getting this onshored as quickly as possible. And the IRA also has 3 different types of incentives in it for domestic manufacturing. It has tax credits for building factories here. It has tax credits based on the units of production for all of those elements I just mentioned. And it has tax credits that flow to us as developers for using domestic content.
Thank you. That's more than I knew, so I always need that. Thank you very much. And one final question is I still kind of try to tie this together. Say the every 3-year IRP, and they identify this much solar or this much other generation. you're not saying that, okay, if it's been identified in IRP, it's become the gospel and it's sacrosanct and it can't change. So we need to go ahead and start preparing for that. We need to do a CPRE for that portion and the dice cast. That's not what I'm hearing, is it? Or is it?
Well, I mean, I think, at some point, you have to make a decision as to
True.
whether or not you actually bring a resource online. And there's, multiple years of lead time between whether you're building a gas plant or building a solar facility. It's 3 to 5 years for each, I would say, longer than that for maybe a combined cycle. And so at a certain point in time, you've got to use your forecast in your plan and say, all right, we're going to move forward with this. And here's how we're going to do it. Here's the process. And I think that's what we're, now faced with solar, where Dominion is identifying 2026, 2027 as points in time where you'd want to add a certain amount of that resource to the system. So if we're going to do that, then we need to procure it essentially in 2024 to hit those marks.
And I would say, Commissioner Caston, that there's definitely been a trend nationally, whereas in the past, the IRP process was often referred to as a paper exercise, as planning, get a big picture sense of things. There is definitely a trend toward the planning process driving procurement. The idea that we've got a lot of resources that we've got to get procured, and the way to do it is to do these studies, bring in a lot of evidence, figure out what we need, and go get it. Now, that doesn't mean that you don't update over time and you don't have new information that comes in, or you test things in the market and maybe you tweak what you do. But I would say the movement is towards a growing link between the planning process and the procurement process.
Kind of the point of planning, isn't it?
Yeah, I think so.
Mr. Davis, Mr. Levitas, both of you gentlemen have been very kind to me, and I appreciate that. I appreciate your responses. And Madam Chair, I don't think I have any more questions.
Thank you, Commissioner Castle.
Thank you, Commissioner. Commissioner Carol Williams.
Thank you very much. Good to have you all here and have you here in person.
Thank you.
I'd be interested in a little bit of comparison. You've done it in a spotty kind of way, but between South Carolina's CPRE law and North Carolina's CPRE law. I gathered from reading the testimony, and this is what I want you to tell me if I'm wrong about, but is that North Carolina is a lot more specific, and South Carolina, it's one line telling us to evaluate this.
Well, let me make one sentence, then I'm going to pitch it to you. A lot of that work in NORCON is being done at the commission. It's not, there's a little bit in statute, but most of it is being done at the commission and with public staff and through stakeholder processes. But Steve.
So I'm wrong.
Well, no, here's what I would say. We've had 2 major pieces of legislation in North Carolina in the last 6 years. The first one created the competitive procurement program, and the legislature made a decision to prescribe a defined amount of solar procurement. And there were reasons that it did that. It thought that that was in the public interest. It was interested in migrating away from a PERPA-driven regime and wanted to introduce more competitive procurement. I mentioned I worked heavily on that legislation. To Mr. Davis's point, a lot of the details were then kicked to the commission, but the amounts of solar to be, it was not just solar, renewable resources to be procured was prescribed by the legislature. And that's not unusual. Virginia has done that by legislation. Other states have done it as well. In 2021, the second piece of legislation, House Bill 951, was not prescriptive with respect to amounts to be procured. As you think you might know, that was driven by a decarbonization mandate that the legislature adopted. It then kicked everything to the commission to figure out how to achieve those decarbonization goals consistent with preserving system reliability and maintaining and having a least cost plan. And the North Carolina Commission concluded its initial carbon plan proceeding at the end of December. And it is an example of this sort of prescriptive commission plan that includes very specific amounts of particular resources to be procured.
does it at the commission level, did they define the steps in the process and the elements that you all have already completed, and as well as the ones that you've mentioned still need consensus building and decision making?
So they had the benefit of having been through a very elaborate process under the prior bill. So the North Carolina Commission actually adopted rules for competitive procurement.
Right.
And the utility, those rules required the utility to present and file a program for competitive procurement. And that in turn led to the specific program documents for each competitive procurement that had to be presented and the timetable in which they had to be presented. So it was quite an elaborate process. So now under the new procurement that is going to occur, that experience is available to be drawn upon, and there are active stakeholder meetings underway, much as Dominion had done with the Urquhart replacement, to determine whether and how those pre-existing procedures should be modified and adapted for this new round of procurement.
I stand corrected, and I appreciate that, because I may go back tonight and read some testimony to see where I got that impression, but I appreciate that. On page 8, you have a chart, and this is more of a curiosity question. It's the chart at the bottom. And what I notice is it's EIA and it's U.S. Plan utility scale electric generating capacity additions in 2023. There is a major amount of solar in December. This is more, like I said, more of a understanding of this, and I realized you would only be able to talk about it from the perspective that your companies participate. Is there some kind of incentive that's inspiring? Is there some kind of requirement out there that's causing that is, and if it's beyond what you know, I understand that, and just tell me.
I mean, it's probably my guess. I don't know definitively. If just looking at this, I'm guessing it's the phase in of the IRA, and what you're seeing is we still have guidance from Commerce and the opportunity to monetize those tax incentives.
So that might be the beginning.
And then you also just have a rush at the end of the year to place facilities in service prior to the next year beginning for tax advantage purposes, and so.
I think that's probably the biggest driver. A significant component of the financing for renewables facilities is it's called the tax equity. That is third parties who are utilizing the tax credits that are available rather than them being used directly by the project developer. And those all depend, the utilization of those credits in a particular tax year depends on the project being placed in service by the end of the year. So there is always a mad dash at the end of the year to try to get projects turned on in order to utilize those tax credits in that year.
Thank you. So this gets at another question that it's inspired by maybe I'm going to pass on that one. It's hard to sit here and filter everything that we have heard from everybody and look at these questions that we've created that I came to me as I was reading last night. Third-party procurement, is that as simple as it sounds? Is it somebody? I guess I'm not sure who the second party procurement would be, but if it's not the utility?
I think that may be a reference to where, Steve, you talk about kind of a build on transfer model where it's being procured, but it's being transferred to utility ownership.
Well, I wrote it after reading on page 14. Line 10.
Yeah, that's always, as I've been a lawyer for a long time, and the use of the term third party's always been a little confusing because I'm never sure who the second party is exactly. So that's a fair question. But basically, what that refers to is the two basic options are the utility owns the resource or somebody else owns the resource, who we refer to as a third party. And then within that construct or optionality, with respect to utility ownership, well, I guess it goes both ways in thinking about designing a program. And this is one of the things that I said takes some time to work out. So with respect to utility ownership, utility-owned assets, are you going to design a program where there's competition for those assets, even though the utility is going to own them? And if so, who participates in that? Do third parties like our companies get to, as typically occurs, get to bid in and offer to sell a project to the utility that the utility is going to own, rather than our continuing to own and operate that project? So that's a question that has to be resolved. You know, at the other extreme, you could say the utility, that's all, the only way it's going to occur. The utility is not going to self-develop any assets. They're just going to buy them from third parties. And then there are multiple purchase structures. Do they buy it turnkey after it's fully built? Do they buy it at some earlier stage? Those are all things that have to be worked out. Similarly, with respect to the third party track, third party ownership, you wouldn't typically, by definition, have a utility participating in that. There have been some cases where utility has a non-regulated affiliate that says, oh, well, we're not the utility. We want to compete to sell our power to the utility, which typically would require changing code of conduct, I think, in most places that keep those things separate. So I hope that answers your question about the distinction between the two, but my larger point is there are a lot of details to figure out with respect to that issue.
It's simple, but yet it's complicated.
Right.
Okay. Let's talk a little bit about the Plexus model and the economic decision-making and the capacity decision-making. It's really the same question that I asked Witness Best. How do we funnel those? How do we, does one kick in before the other? Is it simply a matter of that's part of what the IRP process is for?
Let me see if I'm responding to the question. Go ahead.
I'm trying to give you a chance to answer the same question that I asked Witness Best and see what the answer is.
Yeah, I guess it kind of just goes back to how I answered some of the questions for Commissioner Caston in terms of the distinction between capacity needs and energy needs, and you're satisfying both, right? Like you're making sure you meet your planning reserve margin, and you're stacking capacity resources on top of one another to get there. That doesn't mean you want to run those capacity resources all the time to produce the energy. It may be more expensive, but you need them from a reliability standpoint. And so you're also optimizing energy needs within the modeling process. And that's where you're seeing that solar show up in the Dominion IRP in those years is not as a capacity resource that's needed for reliability, but as a lower cost energy resource that can reduce cost for customers.
And is the Plexus model
where that's being done?
Right.
I believe Dominion's using Plexus pretty much exclusively right now for its capacity expansion and production cost modeling. Yeah.
Okay. So for CPRE, we've heard earlier today this range of perhaps, but that's not been defined, that 50 megawatts might be too little to engage a CPRE process, and 200 was clearly enough. How do you respond to when is CPRE worth it?
I think it's worth having that conversation. It probably as part of some type of stakeholder process if we do that. If not, I think you all should solicit testimony or comments on that. Like I said, I think there's potential to hold fewer procurements and have them target multiple years. One of the reasons we're seeing 300 megawatt increments of solar come online in the IRP is that the model is limited, is capped at 300 megawatts per year. So if you remove that cap, you may see 800 megawatts coming in a year, coming online in a year. I think that's probably going to be a topic that's focused on an IRP this year. So there are a lot of different ways to come at that question, Commissioner Williams. And I don't have a definitive answer. I mean, I would agree, like, you probably wouldn't want to run a procurement for 50 megawatts. I think what you want to do is look out over a reasonable time horizon and say, what's the best way to go get these megawatts in a cost-effective and predictable manner? And probably going to be a couple different ways to do that.
Do either of you have anything you want to add in terms of defining public interest?
I would just point to the balancing factors in the IRP and what's required to reach a most reasonable and prudent means determination. I think generally it's risk and reliability and cost related.
I would agree with that.
Okay. Thank you very much. No further questions.
Commissioners? Commissioner Thomas?
Thank you. I wanted to follow up just a little bit on one of Commissioner Carol Lee Williams' questions, and it relates to the comment on page 14 at the bottom. It says, to be clear, we do not think it's appropriate for utility affiliates to compete in third-party procurements. And to the best of our knowledge, they've not been allowed to do so in states where this approach has been utilized, including North Carolina. I guess my question there is that my understanding is there are a lot of utilities that have unregulated affiliates that are heavily involved in renewable energy. And if that assumption is correct, where are they selling their power?
Well, those companies, I think, most typically develop their projects outside of the service territory of their parent utility, and they do a lot of business. I'm not sure about Dominion, to tell you the truth, but Duke Energy, NextEra, the biggest renewable energy developers in the country are affiliates of investor-owned utilities, and they're working all over the country. But there may be a little bit of imprecise wording in what I said there in that answer in this sense. I was talking about the role of utility affiliates in the context of a program where a defined split has been established either by legislation or by the commission between utility-owned assets and third-party owned assets. So the alternative to that would be to have no split and say, we're just going to let everything compete with each other and let the chips fall where they fall. And actually, the solar industry has advocated for those approaches. It's typically been the utilities who have said, we think there are reasons why we, the investor-owned utility, should be guaranteed a percentage of the ownership of the renewables that are going to be procured. And so in that context, where you've made a policy decision, and it's one that I don't necessarily agree with, but I've agreed to as part of a consensus building process, where you say we're already going to give the utility half of all the procurement that occurs, and we're going to leave half of it for independent parties. In that context, we have said, well, then the utility affiliates shouldn't be taking part of our share. You know, you've already got half of it for the utility, so half of it should be independent.
Okay, thank you.
Thank you, Commissioner. Commissioner Justin Williams?
Thank you, Madam Chair. Good afternoon, gentlemen. Good to see you all again. I can't remember the last time you all were here.
2019, I think. It's been a little while.
Yeah, wow. It's obvious that there is a difference in position regarding a CPRE program and moving forward with the procurement program that Ms. Best testified to earlier today. I want to unpack a couple of things just to make sure I'm tracking you all's position. Is it fair to say that both of you all agree that North Carolina's CPRA program is different, namely because it has a prescribed amount of renewable energy that's mandated for procurement?
I mean, that's a distinction. I will just say that the previous North Carolina legislation that was driving those procurements did have, it was conditioned upon being able to procure that solar under a certain cost cap. So it wasn't just go procure it no matter what. It was, if you can get it under your avoided cost, then get this much.
Okay.
And that's correct. And here's how I would just elaborate on that response a bit, Commissioner Williams. I take your point. There is not a comparable legislative mandate in South Carolina as there has now been in two pieces of legislation. Well, let me be clear. The first North Carolina legislation specifically mandated the procurement of a defined volume of renewable energy under specific circumstances which Mr. Davis just described. The second piece of North Carolina legislation mandated decarbonization of Duke's fleet, which is only going to be possible with the addition of significant renewables. Didn't have a renewables number. But again, you had a legislative driver that led to, in both cases, defined procurement of renewables. So CPRE type procurement of renewables. In the absence of such a legislative mandate of either of those sorts here in South Carolina, what I would point to that would potentially lead you to a CPRE procurement in South Carolina are the requirements of your integrated resource planning. Well, first of all, the legislature authorized you. They wouldn't, you could say they wouldn't have authorized you to do a CPRE if they didn't think it was something worth you're taking a look at. And so they must have had something in mind as to why that could be beneficial. But perhaps even more significantly, when you look at the factors that you're required to consider in doing integrated resource planning, as we've hit on a number of times, those include risk to ratepayers and I believe fuel volatility or fuel commodity costs are specifically considered. And so the way that you would, in an IRP process, if we've suggested you need to look to the IRP, the way you would get to a decision to do CPRE, renewables only procurement, is if in that planning process you conclude that it is whatever else happens, it is in the best interest of the ratepayers of South Carolina. It's in the public interest for there to be a defined amount of renewables procured, which I would submit would precisely, it could be one of two reasons. One, it could be because of the fuel diversity, and that's the only way you're going to get fuel diversity and protect ratepayers from gas price shocks. Or alternatively, based on the information that you get in the IRP, you may well find that this resource, as has been documented in many contexts, is so much the cheapest resource that is available that you would say, well, there's a certain amount of this that we just know we need to do. Maybe once we get past a certain volume, we need to look at a bunch of other things, but you might well conclude, we just can tell, we need X 100 megawatts of solar, whatever else we do. But you would be getting to that decision not because the legislature gave you that degree of specific direction, but they gave you the tools to reach that conclusion.
I understand, and I appreciate you all laying that out for me. Just as an observation, what's not crystallizing for me is how either process, whether CPRE or the Urquhart procedure, will trickle down to tangible, quantifiable ratepayer benefits. I'm not seeing how either one will do that based on what what I've heard today. So my question is, in terms of the ratepayer perspective, because we know that public interest is not only ratepayers alone, residential, commercial. Public interest has involves more than just the ratepayer perspective. But what difference does it make whether we use CPRE or the Urquhart procurement method? For ratepayers.
So if you have a variable fuel resource like gas that's competing in an all source procurement against a fixed cost resource like solar, I mean, there's just a question there of what are your assumptions about those gas costs over the term you're trying to procure it. And so from a ratepayer perspective, that I think that's what the General Assembly set out to do, is establish those balancing factors in the IRP. So that's exactly what you're looking at. And you all have required the utilities to use cost sensitivities to make different assumptions about different inputs related to technology costs. And you're zeroing in on a portfolio that meets all of the various requirements of the statute. And then when you go to the market and test it, there's no way to test that gas assumption because no one is going to bid that cost in. And so the ratepayer benefit shows up by having gone through that IRP process, evaluating the cost risk, assumptions around different resources. And then in the case of a CPRE for solar, you're market testing to make sure your assumptions are validated. And to the extent they are, you can go contract for that energy, and those benefits have been defined in the IRP. I mean, the solar is showing up in Dominion's resource plan because, at least based on the cost they assumed, it's cheaper than the alternatives. And so it's being selected as being in the best interest of ratepayers. I mean, I agree with you, Commissioner, that the argument, and if it's not clear from how we're talking about this stuff, we aren't making an argument that Dominion should just go procure solar just because. It should be vetted through an IRP and validated as a least cost, least risk, diversity option that the statute supports.
And if I may, I agree with that. And just to pick up on what I was saying earlier, Commissioner Williams, the premise for a CPRE solar-only procurement would be a determination by this commission that the public interest would be served by adding solar resources to this system. That's the only reason you would do it. You would have to have made a finding that that's in the public interest to uniquely add solar to the system. And as I was suggesting, why would you make that decision? Given your current legislative authority, it would be to insulate ratepayers from these enormous potential risk of fossil fuel price volatility. And so just like you might hedge a personal investment portfolio, you would say, well, we've got all these other resources on the system. We're subjecting ratepayers to huge potential exposure because of fuel costs and federal regulations, I might mention, of fossil fuels. So we, the commission, are going to find that we need some solar on this system to protect our ratepayers from that kind of volatility. So we're going to go procure solar. There's no reason to procure it in competition with something else because you've made the determination that what you need is solar, not solar maybe if this then, but you've made a determination that's in the public interest. You asked about the public interest with respect to all source procurement. That's a different calculus or a different circumstance. The reason that people do all source procurement is where you have a capacity need, like the Urquhart situation, where you're thinking about either you've already decided that a plant is outmoded and needs to be retired, or you're considering whether it makes sense, whether it's in the public interest to continue operating that plant. And you say, well, what are our options? What are our options for replacing that capacity? And in that context, there's a lot of benefit to an all-source procurement where you can look at all the range of options. And one of the great things about all-source procurement, and I think maybe Witness Best mentioned it, is you can fashion a portfolio. So it's not binary, it's not this or that, it's a mix of things. When you're talking about large scale, retiring multiple 100-gigawatt plants, and you think about the energy function that might be provided by renewables and the capacity with a gas peaker, there's a really interesting process of piecing those things together. But it's a totally different situation and different consideration than when you're just answering the question that I mentioned a minute ago of how do we have a fuel mix on this system that reasonably balances risk to our ratepayers and doesn't put all our eggs in one basket.
Understood. In referencing Witness Best's testimony, I think I understood her to testify that as a general matter, she prefers or she advocates for all source procurement versus CPRE. Do you have any comments about that? Either one of you. I know there was a question as to how you all should testify, but
I'll just note that one of the things Witness Best says in her testimony, and she said from the stand, was that you still want to specify what it is your system need. So if you need a 8-hour capacity resource, you're not going to go. Solar doesn't provide that, right? We know solar doesn't provide that. So designing an all-source procurement that would allow solar to bid in and compete would add complexity and cost unnecessarily to that all-source procurement. So, I agree with her that you can narrow these procurements based on system needs. When you're talking about an energy need, in this context, in the context of Dominion IRP, the only technology that I'm aware of and that Dominion has pointed to is solar. I mean, this point by Witness Best is confusing to me.
You're not the only one that's confused, which is why I'm asking so many questions.
I actually don't understand what her argument is as to they've identified a price point at which solar makes sense for them to purchase. Why you would then go do an all-source procurement to test it against what?
Exactly.
I fail to grasp the kind of point being made.
Well, I need you to figure it out because I am confused too. So let's try to work through it together. It has to be, or is it just from an academic perspective, could it just be a academic argument that it is better to have all source procurement versus a single source?
My response is both and. It's not a binary decision. There are some circumstances, this is what I was just trying to elucidate a minute ago, there are some circumstances where all source procurement is the right approach, and there are others where the CPRE approach is the right approach. And at the risk of oversimplifying, I think what Mr. Davis is saying that I agree with is that where you're addressing energy needs on the system, in many cases, there's no purpose served by an all-source procurement because you've decided you need a particular energy source and it's available at the least cost. When you're going to replace capacity, it's a much more complicated process because I believe today, this is a paradigm shift, but where we are moving today, Colorado is a good example of this. When you go to retire a coal plant, or I think we're going to hear on Urquhart that it's going to be a mix of things. It's not going to be one plant. When you go to retire a major thermal energy station today, the correct solution, I think, in most cases, is going to be a mix of resources. In Colorado, I mentioned it earlier, it was solar, wind, gas, storage, and the utility went into the market with the all-source procurement, put together this portfolio, brought it back to the commission and said, here's what we think is the right mix. So I'm all for all-source procurement in that context. But what we're dealing with right now is Dominion IRPs, which are showing a need specifically for solar because of energy considerations and the fact that that is a way to reduce volatility and ratepayer risk and bring low-cost energy onto the system. So it's just two different inquiries, two different situations.
And so your argument is the mere fact that in South Carolina, Act 62 empowers the commission to at least conduct a hearing to determine whether or not a competitive procurement, a renewable energy program is in the public interest is suggestive in that it may very well be.
Yes.
Okay. And your argument is not to implement it now, but at least create the framework for such now.
That's correct. So maybe I'll give you an analogy, if I might, close to home. I had a bike accident a couple of weeks ago, and I've been doing everything I could think of to try to heal my ribs and manage pain. And so I give you a long list of all the things that various people, my wife, my doctors, tell me I might do, and I could weigh the cost benefits of all those things. But the one thing I know that I need to do is take ibuprofen. So I'm not like going through an elaborate process to see how ibuprofen compares to ice and heat and doctors and x-rays and all this sort of stuff. I know I need to do that. And that's where, what we would represent to you in the context of the public interest in the energy future is that there is a known need to bring solar onto the system as a least cost, low risk energy source. There are a lot of other questions to be answered, a lot of complexity about the overall long-term resource mix, when the coal gets retired, what it gets replaced by. But given that known immediate need for solar additions to the system, then that's what we need to go get. That's what needs to be procured, not some elaborate process to consider 6 other alternatives.
And what is the disadvantage of waiting? I mean, I understand from an academic perspective, we should do it now, but what will a ratepayer lose by waiting until 2026?
Yeah, I mean, so their opportunity cost, right? I mean, it's the same thing we've seen over the last 2 years, where fossil fuel volatility shot up, and you all have been handling kind of fuel rate increase after fuel rate increase, and you could have mitigated that via solar procurement a few years ago. In 2020 IRP, had those resources been online early, then potentially, not potentially, then you would have mitigated some of that exposure to those fuel costs. But looking forward, what Dominion's telling you in its IRP is that solar is cost effective and saves our customers money in every year on the planning horizon from 26 to 2049. But if we're not active in putting that program in place and then procuring those resources, they're not going to be online in 2026. I don't think they're going to be online in 2026, even if we started today. I think 27 is probably the earliest you're realistically going to see it. And so every year those resources are not online, that represents a premium cost that those customers are paying for an alternative fuel source. In this case, some combination of gas and coal.
Isn't the company suggesting, though, that the current framework through PURPA will meet those needs?
PURPA doesn't produce a least cost product. I mean, you've got a 10-year fixed rate option that's not dispatchable by the utility, and it's set based on the avoided cost. So it's meant to keep ratepayers harmless. It's not meant to save them money. And with a competitive procurement, especially with a longer contract term, which is, typically we're seeing 20 to 25 years in the procurements around the Southeast, you're getting a delivered energy cost that's significantly lower than the utilities' avoided cost.
Gentlemen, thank you for indulging me. I appreciate it.
Thank you.
Madam Chair, that's all I have.
Commissioners?
Madam Chair.
Commissioner Irvin?
Gentlemen, I've followed your testimony with interest, and I'm going to try to probably oversimplify the discussion, but it all comes back to fuel sources in my mind, because what we're talking about when we talk about solar procurement is a generation method that does not require fuel. And you start out, therefore, with a substantial savings. Do you agree with that premise?
Yes, sir.
Yes, sir.
And, you know, as long as natural gas prices were relatively stable, we didn't really worry too much. But once we saw the volatility where the pricing increased over 100%, I think closer to 110% at one point, year over year, it becomes a tremendous burden on ratepayers, does it not?
I agree. I think you guys have seen the burden that potentially represents on ratepayers of late.
Right. And so because under South Carolina law, the fuel charges are passed on to ratepayers dollar for dollar, 100%, we have to look for ways to lessen that impact, whether it be gas, natural gas prices, or coal prices, correct?
I agree, sir. I think that's written into the IRP statute as well, that fuel diversity and risk consideration around commodity prices is actually, you're charged with making those considerations.
And given that in South Carolina, wind is not a viable option currently, agree with that?
I think that's right.
Hydro is very limited in its availability and no longer really considered a generating resource in the big picture. You agree with that?
I think generally we're not going to see a ton of new hydro.
And nuclear is limited by the fact that we learned a painful lesson here in South Carolina when SCANA tried to build a new nuclear facility, and due to cost overruns and fraud, it was never completed. And of course, our neighbor Georgia has experienced similar problems with their new nuclear plant that's still not up and running. I understand that they say it's ready to begin, but there've been billions and billions of cost overruns waiting to be put into rate base on the backs of Georgia ratepayers. So it's not really a viable option in terms of new generation. You agree with that?
Not in the near term.
Maybe in the long term with smaller reactors, but they're still kind of in the developmental stages. Is that fair to say?
We have not seen any deployed in the United States. I think we'll start seeing those next decade.
Right. So for the foreseeable future, the next 10 years or so, our options in South Carolina are limited to natural gas and solar. That's basically what it comes down to, right?
Yes, sir, and energy storage as well.
Right, and energy storage is still not quite where we'd like to have it. You know, I think that what's generally available in the marketplace right now is about 2, maybe 3 hours. What we really need is 8 to 10 to 12 hours, and it's not commercially available yet, is it?
I would say, and you'll probably see this in Dominion's IRP. I think you do see it in the 2023 IRP, is that 4-hour storage actually does and can play an economic and reliability role on the system. But as you add it, then yes, you will need longer storage solutions going out 6, 8 hours. So
Right.
it's
Right.
limited but significant in its potential.
Correct. But it won't come into play in a big way for another 5, 7 years. Is that fair to say?
I mean, I would say 4-hour storage is competitive in the market today. You've seen some PPA execution with Dominion that includes on purpose side that includes storage at Dominion's avoided cost rate. So I certainly think it is competitive at the 2 to 4 hours today.
It's worth a look, but in terms of new generation, we're still kind of left those two major choices of either natural gas or solar in South Carolina. kind of what it comes down to, isn't it?
Those are the major options, yes.
And one has a fuel cost and the other does not. So it seems to me that if you're going to have a diversified portfolio, and those two choices, you've got to have both in your system that can be supplemented by our existing nuclear and hydro and whatever else we can come up with, some storage. But that's the best way to reduce the risk of unanticipated fuel cost increases for ratepayers. Am I getting that right?
I think it's a primary option that's been put on the table by the utility and that we've advocated for, and it should absolutely be in the mix. I think when you hear from the Conservation League and others, they'll talk about demand response and energy efficiency as well. But from a generation standpoint, solar is the option for mitigating fuel volatility in the fossil markets.
And in fact, some states have pretty much, you might argue, have really gone overboard in the sense, if you look at what's happened in Hawaii, because it costs so much money to ship oil and natural gas out to the island, and to a lesser extent, California, they've pretty much gone almost all renewables, have they not?
That's true of a number of states. I know Oregon is on that list. I think Washington State may be. Virginia's Clean Economy Act, I don't know if it gets to 100%, but it has very aggressive renewable energy goals.
Right.
And procurement mandates.
Right. So even though we don't have a procurement mandate in our statute, or Act 62, I guess where I'm coming down is, isn't it just common sense to kind of reduce risk for ratepayers? And tell me if I'm wrong, but there are only a couple ways to do that. I mean, one is to ask the utilities to share the risk of a spike in natural gas prices. I don't think they're going to like that. I don't think they'll volunteer to do that. I think 16 states have mandated that they take a share of the fuel costs. South Carolina's chosen not to. The only other option is to find a resource like solar that requires no fuel. And it just seems to me that fairly simple. If you think about it in those terms, the only way to protect ratepayers is to diversify into solar. And as you just pointed out to Commissioner Justin Williams, PURPA's not going to do it because it was a good attempt, I think, by Congress to try to promote renewables, but avoided costs is just not going to ever propel PURPA into the forefront. It's going to, it's just not going to work. And so I think that what it comes down to for me is diversification. If you're going to have more than, either you build all these peaker plants and their useful life is what, 30, 40 years? Is that right?
Between 25 and 40.
Yeah. And then as renewables come online and as the technology improves with 10 and 12 and 14-hour storage, they become obsolete and become stranded assets on the backs of ratepayers on the back end of that 30 or 40 years. And so then what do we do when that happens? I'm not sure anybody knows. I guess, I mean, what would a utility do if they no longer needed those new gas peaker plants in say 25 or 30 years? But they haven't been fully depreciated. They would come in and want to, what would they do? They securitize the remaining
You know, if our legislature authorizes securitization for those type of resources, then that would be one option. But I mean, yeah, typically what you see is some type of accelerated depreciation, and you know, you're waiting until whatever else is out there competing in the market can come in and provide a lower cost that also includes that depreciated or undepreciated value. So it's difficult. It's difficult to walk away towards more cost competitive options when you have essentially a stranded asset on the system.
Yep, and again, that puts it right back on the backs of the ratepayers, doesn't it? Because that's going to be an itemized, a line item on their utility bill. If the stranded asset, the gas plant that's no longer needed, of course, the utility has a right to come in and ask that it be securitized, and not under existing law, but under some states, they're already doing, as I understand. Is that right?
Chair Belser, may I don't have an objection. I don't have an objection. I would just like to note in the record, though, please, that no foundation has been laid for these two gentlemen to talk about some of these topics, whether a utility would come in for securitization, how a utility respond to events. Please continue the discussion. I would just like the record to note there is no foundation for that.
Noted.
Well, let me just back up then, and I apologize, should have laid a foundation. Have you all had any opportunity to look at what other investor-owned utilities around the country are doing in terms of long-term planning?
Yes, sir.
Yes.
In fact, you testified before North Carolina Commission, and I believe you said to other commissions in similar proceedings. Is that right?
I've worked directly on consumers energy in Michigan's IRP, Georgia Power IRP, Duke's IRPs in North Carolina, Santee Cooper, Dominion.
So the concepts that I'm asking you about are not new to you. In fact, you've been directly and personally involved in them. Is that true?
Yes.
Okay. So with that foundation, I'm going to wrap it up and just say, you mentioned that there's several things that the South Carolina Commission could do now to lay the groundwork for process so that we don't find ourselves having to push the calendar out beyond the need. And so if you had to prioritize next steps, what would you tell the South Carolina Public Service Commission should be the next steps in the process in terms of your worldview? What do we need to do, if anything, at this point?
Well, I was just going to say more generally, our view is that the commission should go ahead and put a procurement program in place, both a CPRE program. I think it would be well advised to go ahead and address the design of an all-source procurement program, which I think you have broad authority to do. Maybe, I don't know whether that's in this docket unless it's going to involve renewables. But our point all along has been that they're coming, they're needed, they're more complex, we believe, than what is best suggested, and there's work to be done with significant consensus building. But to prioritize specifically, I would tell you the single biggest issue that I run into everywhere that I work on this is the issue that I've talked about of what I'll call the ownership split, but the relative role of the utility and third parties. And that is an issue that we have spent months and months and months negotiating on in other states. There's lots of examples from other states, but it's going to take a long time to resolve that. I hope we can achieve some consensus around that. I mentioned the issue.
Let me ask you before
Yes.
you move on to the next
Yes.
one. How have other jurisdictions resolved that issue?
I would say mostly in an arbitrary way through a politically negotiated solution. There have been some attempts to try to quantify that based on various criteria and ratepayer interest and what would be least cost. But at the end of the day, in every state that I know of, there's just been a political solution where the utilities are not willing to give everything up. There's a recognition of the benefits of third-party ownership, and there winds up being a split that is described either by legislation or by commission action. And they have ranged from 35-65 to 50-50. But that takes a lot of work to figure that one out.
Is that something that could be, that a stakeholder process could be working on?
Yes, sir. I've been involved in multiple stakeholder processes working on that very issue.
In fact, that's probably the best place for it to occur, since we don't have a statutory mandate to do it. If you all could work on it as a stakeholder group and come to some resolution, do you think that would be time well spent?
I do.
Okay. So what's the next thing?
The next thing, and I'm not sure if this has been addressed in the context of the Urquhart RFP, but there's a significant issue related to the allocation, the interrelationship between the RFP, the procurement process, whether it's CPRE or all source procurement, and the interconnection study process. So how those things sync up so that you have interconnection cost information in scoring your bid proposals, which are just based on generation, and also the critically important question of how the cost of any upgrades to the system are going to be allocated. And that has taken, again, a tremendous amount of time. It's a very hot issue at the national level on the cost allocation. Again, stakeholder process is a good idea, but it takes a lot of time.
Well, there must be some best practices out there. Other states have been able to work through these issues. Is there any kind of consensus best practice about how to work that out?
Well, I can tell you in North Carolina, it seems to have been recognized that the ratepayers are going to pay for upgrade costs either way. Either you take those upgrades and you put them in the rate base directly, and they're paid for by ratepayers, or if you assign them to bidders, then the bidder is going to have to increase their cost in order to cover that additional item of paying for transmission system upgrades. And the danger of that latter approach is that when bids come in, that the bidder will not have certainty about what its upgrade costs are going to be and may potentially then have to inflate its bid to cover a worst case scenario. And so you could wind up actually with higher cost to ratepayers because the bids have overcompensated for unknown upgrade costs. I realize I'm hitting you with something kind of complex, but
that makes sense. I mean, bidders are going to hedge their bets, so it sounds to me like the better solution is to allow the investor-owned utility to put it in rate base.
That's my view, yes, sir.
Transmission cost. Yeah.
Yes.
So that should be a fairly simple one to resolve. What else do you have on the list?
Well, I mentioned storage will be a part of any of these procurements, unless there's a decision to do a pure energy solar only. But storage is coming. It's part of the. It's going to be part of the. It is part of the IRP, and when you get into designing and structuring the price mechanisms and the contractual terms of a solar plus storage PPA, things get very complex. There are a lot of different ways to go on that. As I said, that is the topic of an active stakeholder conversation in North Carolina that Mr. Burns and others are heavily involved in, and it has not been easy, and we don't have an answer yet. So we need to, I would respectfully suggest that that is something that needs immediate attention in South Carolina as well.
And perhaps what you're doing in North Carolina can serve as a guide forward or a pathway forward, since the utilities kind of overlap in service as well in South Carolina to some degree.
I would mention one other thing, Commissioner Irvin. It may be there. I've mentioned a couple of times that there are assumptions that have to inform any procurement process, particularly an all-source procurement process. But some of the big ones are: what assumption do you make about what you expect gas prices to do in the future? What assumption do you make about how solar is going to contribute to capacity? And there are a number of others. And it may be that the answer is you just decide all those things in the IRP proceeding and say that will govern the RFP, and those will inform decisions made in the RFP. But that hasn't been decided for sure. Somebody might say, well, no, there's a different way that we ought to address those. So I would just put that under the heading of determining how assumptions will be established that will inform the comparison of different resource bids?
Well, you've done a good job of outlining the main issues that have yet to be dealt with. And what I've noticed, in this proceeding and in other proceedings, that the stakeholder process really does work. I mean, you've got, you all have, you've got the resources and the expertise to do it. Quite honestly, I don't know how we would begin to do it. And so I'm wondering if it might be best just to empower the stakeholders to work on it and report back to us in a certain period of time. Doesn't that make more sense than trying to force some kind of model on you that may not work or may not have best practices?
Yes, sir. I mean, I think that's pretty close to what CCBA's recommended in this proceeding, is that the commission ordered the parties to go engage in a stakeholder process and then come back and file a proposal. And to the extent there are non-consensus issues, the commission can resolve those, either in a written docket. Hopefully we won't have to come back and do another hearing. A lot of the times these things can just be dealt with on paper. So that's pretty consistent with what we're hoping to walk away from this
well,
with.
You guys have been at this, for a long time, and the company has great resources as well. And I think that you all are better suited to, to work through this list of issues really on your own and come to some creative solutions and some give and take. And that way, we don't have to be asked to render some kind of order that may not work for anybody, because you all really kind of know what you need. You're doing it at other states and at other levels. So I would highly recommend that you consider that. And I appreciate, and I want to thank all the participants for being with us and helping us better understand these issues. Thank you, Madam Chair. No further questions.
Thank you, Commissioner Irvin. Gentlemen, thank you for your patience this afternoon. Just a couple of questions. One of the things that I was wondering about is, with the stakeholder process, if the commission asks the parties to engage in that, what kind of time frame are you looking at? You've indicated that there's some very contentious issues in other states that you know about. I'm just curious as to a time frame. Is it 12 months, 24 months?
No, I think we can do better than that.
Okay.
I would like to think, I don't want to over-promise, over-commit, but just based on my experience in other states, probably 6 months.
Okay. And I think one of the reasons I'm asking that question is, I think in your pre-file testimony, I know Mr. Davis has indicated it here today, that depending on what happens with the IRP, Dominion's IRP later this year, and where they've indicated a need for solar in 2026, that if a process isn't started before the end of the IRP, resources might not be ready to come on in 2026, and you indicated maybe not even 2027. Is that right, Mr. Davis?
I mean, I would say 2027 is close to a best case scenario.
Okay. Not 26, but possibly 27.
27.
Okay.
But again, I mean, it could be longer than that too. I mean, they're just a lot of uncertainties as to study timelines, construction timelines, and so I think that's the sense of urgency we feel, is being prepared to act in the face of the final 2023 IRP order.
Okay. Mr. Levitas, I had one little nitpicky thing. If you'd look at your direct testimony on page 26, and I was just going to clarify this for the record, if you don't mind.
Yes, ma'am.
I'm in footnote number 9, and there's a number in that first line that's 1,00 plus. Is there a digit missing from that?
Thank you. There is a missing 0 there.
So it should be 1,000 plus?
Yes, ma'am.
Okay, thank you.
Thank you.
Commissioners, further questions? Okay. Any redirect? I know we're running a little bit long here, but
No redirect, and may these witnesses be excused?
I will tell you that witnesses may step down. I tell parties you excuse them at your peril in case something comes up between now and the end of the hearing that somebody may want to ask a question about. So I'll leave that to y'all's judgment. Sorry, Mr. Witt.
Thank you, Chair.
That's just my practice.
Thank you all for the time and attention today.
Thank you so
Thank you,
much.
gentlemen. We've been going, gosh, what, 2.5 hours almost? And I know the court reporter needs a break. I don't see us finishing today since we need to end it at 5. Do y'all want to try to put Mr. Moore up, even if it may indicate splitting his direct and cross and commissioner questions?
Sorry, you have to push that button really hard
You
to
really
get it to
do.
turn on. I think our preference would be to try to at least get his testimony entered into the record this evening, and then
Okay.
you carry over.
Hold on just a second. We need a 5-minute break, if you don't mind. Let's come back at 4:35. Good afternoon and welcome back to the Public Service Commission. We are continuing with the hearing in docket number 2022-238E. Let's take a roll call of commissioners. Present in the hearing room, we have Commissioner Justin Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Carol Lee Williams, Commissioner Caston, Chair Belser, and with us virtually we have Commissioner Irvin. Mr. Barnes, you got an issue?
Not really an issue, but for your planning purposes, I've informed Mr. Huber that CCBA has no cross-examination questions for ORS's witness, given how detailed the testimony to date has been. So,
okay, thank you, sir.
I'm fine with that.
Thank you. Ms. Mixon, recognize you for SACE CCL.
Thank you, Chair Belser. CCL and SACE call Eddie Moore to the stand.
Good afternoon, Mr. Moore.
Good afternoon.
Okay. The court reporter will swear you in.
Thank
Mr.
you.
Moore, if you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Great. Thank you, Mr. Moore. Can you please state your name for the record?
My name's Eddie Moore.
And by whom are you employed and in what capacity?
I'm the Senior Energy Program Director for the Coastal Conservation League.
And did you cause to be pre-filed in this docket on February 7th, 2023, direct testimony consisting of 12 pages?
Yes.
And do you have any changes or corrections to your pre-filed direct testimony at this time?
No, I don't.
If the answers put to you in your testimony were asked of you at the hearing today, would your answers be the same?
Yes.
And did you also attach to your direct testimony one exhibit identified as Exhibit 1?
Yes.
Was that exhibit to your testimony prepared by you or under your direction?
Yes.
Chair Belser, I'd now move to have Mr. Moore's pre-filed direct testimony entered into the record.
And Chair
as if-
Belser, before you answer, please finish, but I just wanted to be recognized before you answer.
Yes, sir. Ms. Mixon, please go ahead.
I would move to have Mr. Moore's pre-filed direct testimony entered into the record as if given orally from the stand.
And Chair Belser, I talked with Ms. Mixon at the beginning before the start of the hearing to let her know, sorry, commissioners, is this better?
Yes.
I talked with Ms. Mixon prior to the start of the hearing to let her know that I would raise a motion in front of the commission so we could talk in advance, and this is nothing she's not expecting. There's some line in Mr. Moore's testimony that we may choose to ask questions on and just to explore what he's proffering these to show, his familiarity with it, his basis for offering it because it relates to somebody else's study. At that time, we may object to this testimony. We may move to strike this testimony. I don't know that now because we haven't had a chance to cross-examine him. My suggestion to Ms. Mixon was that we have this moved into the record with a stipulation that the company does not waive its rights to ask him questions about this portion of his testimony. And if we feel like there's not sufficient foundation or we feel like it's prejudicial, we still may have the right to just make a motion to have this portion of his testimony struck. Still be before the commission and be the chair's prerogative. We just don't want to waive our rights at this outset.
Understand, Mr. Cooper. Ms. Mixon, is that your understanding?
That is my understanding, and I'd be happy to address or respond to any objections that come up.
At the time?
Yes.
Okay. Thank you, Ms. Mixon. Please, okay. With that in mind, we will enter Mr. Moore's direct pre-filed testimony into the record as if given from the stand, subject to motions later.
Thank you.
Possible motions later.
I would also move to have Exhibit 1 as attached to Mr. Moore's pre-filed direct testimony entered into the record as the next hearing exhibit.
Mr. Moore's exhibit attached to his direct testimony and as CCL SACE Exhibit 1 will be marked for identification as hearing exhibit number 1 and received into the evidence of this case.
Thank you. Mr. Moore, did you also cause to be pre-filed in this docket on March 7th, 2023, surrebuttal testimony consisting of 5 pages?
Yes, I did.
And do you have any changes or corrections to your pre-filed surrebuttal testimony at this time?
No.
And if the questions put to you in your surrebuttal testimony were asked of you at the hearing today, would your answers be the same?
Yes.
Chair Belzer, I would move to have Mr. Moore's pre-filed surrebuttal testimony entered into the record as if given orally from the stand.
Mr. Moore's pre-filed surrebuttal testimony will be entered into the record as if given orally.
And Mr. Moore, did you prepare a summary of your direct and surrebuttal testimony?
Yes, I did.
Would you please read your summary to the commission?
Yes. My direct testimony urges the commission to find that it's in the public interest for Dominion to work with stakeholders to create a competitive procurement of renewable energy, or CPRE, program to be in place and ready following Dominion's 2023 integrated resource plan proceeding, so that cost-saving resources can be procured as quickly, cost-effectively, and transparently as possible. While Dominion asserts that developing a CPRE mechanism at this time will not serve the public interest, extensive evidence shows that CPRE would reduce the fuel costs that ratepayers pay and reduce volatility in that cost. Dominion's own testimony describes certain benefits of collaboratively developing a competitive procurement mechanism, and Dominion's IRP modeling shows that near-term solar additions will provide economic benefits for ratepayers. Dominion's preferred IRP plan and every other build plan begins to add significant amounts of solar in 2026 and continues adding solar in every year for 20 years or more. Dominion's other IRPs, the testimony submitted in the generic CPRE docket, and last year's fuel proceedings provide even more evidence that developing a CPRE process would ensure that there's one more tool in the toolbox to benefit ratepayers. While Dominion will witness best testifies in rebuttal that Dominion does not have a capacity need until 2029, a capacity
Mr. Moore.
is not the only type of
Mr. Moore, I'm sorry to interrupt, but we're having some connectivity issues, and we're missing some syllables and possible words. So I need you to back up a little bit and let's try again.
Yes, I'm sorry about that.
If you could go back a few lines.
Dominion would, yes, ma'am.
Thank you.
Okay. While Dominion Witness Best testifies in rebuttal that Dominion does not have a capacity need until 2029, a capacity need is not the only type of need recognized in statute or reasonably needed by ratepayers. Dominion's series of IRPs since 2020 and Dominion's recent fuel cases document the need for fuel cost savings and the fuel cost hedging provided by increased generation diversity. The energy provided by additional solar.
Mr. Moore, hold on. We just had you.
The need to run. Yes,
we just had you freeze, and so we missed something there. Let me check with my technical folks to see what we need to do. Do you have do you have several things open on your computer? They're telling me your bandwidth is showing as real low on their screens or dials or whatever they're looking at back there. Your computer keeps buffering.
Let me see if I can reduce that, please. Let's see here. Perhaps this will be better.
Okay. You think you're ready?
I think I'm ready.
All right. I'm going to ask the court reporter to tell you where you need to start, if you would. Hold on a second. Ms. Jo?
Mr. Moore, I have up through fuel cost hedging provided by increased generation and diversity.
I also respond to witness Best's claim that there's no need to rush. She outlines a series of steps which, by my estimate, CPRE development, RFP issuance, bidding, evaluation, regulatory approvals, and an actual project development, construction, and interconnection could mean that another full IRP cycle will come and go without ratepayers getting the benefit of CPRE, even if the commission does agree that the IRP identifies a substantial need. Throughout that delay, ratepayers will pay 100% of fuel charges pass through, even if lower marginal cost resources could have been brought online sooner CPRE. And Dominion would continue to be the last major utility in South Carolina to address CPRE more than 5 years after Duke. To be clear, I'm not recommending that Dominion administer a CPRE program immediately. Rather, I recommend that Dominion begin to develop a process with stakeholders so that it can be deployed in a timely manner when the 2023 IRP is approved. This is a very reasonable step to ensure that ratepayers can benefit from any cost-saving opportunities identified in the IRP. This concludes my summary.
Thank you, Mr. Moore. Mr. Moore is available for cross-examination and questions from the commission.
Ms. Mixon, we need to finish by 5 o'clock, so we're going to postpone cross-exam and commissioner questions until in the morning. Sorry about that, Mr. Moore, but we do need to conclude by 5, and I don't want to cut off any party that may have questions. With that, I do tell you, Mr. Moore, you're under oath, and you need to not discuss your testimony or have anyone discuss it with you with regard to this proceeding until in the morning. And with that, we are in recess until 9 a.m. on Tuesday morning.
Chair Belzer, if I may
9:30. 9:30 a.m. But yes, ma'am, Ms. Mixon.
We would, I know my co-counsel and I would really appreciate if we might be able to appear virtually tomorrow morning. I think we were kind of anticipating the hearing would wrap up today. So would just ask whether that would be amenable to the commission.
Yes, you may.
Thank you.
Chair Belser,
Mr. Rich.
And I also would like to appear virtually tomorrow.
I had this thing on my calendar for all week. Did everybody else not get the memo?
Well, we
relied on my local council.
We thought it'd be one day. We didn't realize the hard stop.
Yes, sir. Just be sure, make sure before you leave that you have completed the virtual media survey so that the technicians in the back, our ladies, can make sure that you have the requisite link, whatever they call it, that you can.
Carrie just left a few minutes ago, and she was going to put us both in for virtual, subject to your approval.
Yes, sir. Thank you. Anybody else?
Thank you.
Chair Belzer, I will be here tomorrow. I'll just be relieved to let the hotel know I'm checking out early. I won't be here all week, but just we'll be back tomorrow. I
do anticipate us finishing tomorrow since we have 2 witnesses left.
Thank you, Chair. I did want to just mention to the chair that witness Best has been allowed to step down. She does have an appointment in the morning, but is available from noon on tomorrow. Should there be something odd that came up? Just wanted to put that to the chairs in front of the chair tonight. Thank you.
Thank you. Anybody else? Any issues? Ladies and gentlemen, thank you for your participation today and for your patience. And we look forward to seeing you tomorrow morning, either in person or virtually. And with that, we are in recess until 9:30. I think I said 9 o'clock. 9:30 tomorrow morning.